Instead of being protected, this domestic violence survivor was sentenced to 20 years in prison. Was it justice or a system stacked against her? This is the Marissa Alexander story.
This sounds like the Nikki Armando story.
Doesn't it? It's very similar. Yes.
And I shouldn't even say just Nikki, because it's like we know of a number of women, actually, that kind of this issue was involved. But it just reminded me of Nikki's case.
Yeah. This one's going to infuriate you. And I think it will infuriate our listeners just the same. But hopefully it will inspire everyone to do more to support women like Marissa, and also to try to get some of these antiquated laws changed.
How did you hear about this case?
Actually, I think it was I'm almost positive that it was a patron.
Well, our patrons have the best suggestions.
They do.
And we had such a good time last night with them. Oh, my goodness.
Oh, I know. It was our biggest one yet.
It was incredible. I feel like we could have gone for hours, even though I was starving for dinner. I got to eat before these things.
I know. No, it was really fun. I always learned so much from everyone, too. It's so really much. Cool. And also, it's kind of cool that people are friends with each other outside of like our happy hours. It's cool.
I know. I love that.
And we did talk about potential meetups. And actually, while we're on the topic, we are doing a live panel event on November 5th at Fairleigh Dickinson University in New Jersey. Mm-hmm. We've heard from a lot of you that plan on coming. We'll be doing a little meetup with our patrons before. Mm-hmm. And I am so excited. We've been talking about doing some sort of live event for years now.
I know. We should mention, though, someone had asked, because there's two campuses. We'll be on the Florham Madison campus.
Yes. For people that don't live in New Jersey, that's totally irrelevant. But those of you who live around here, it's very relevant because there are two campuses. But if you live in New York, Brooklyn, like I said, the tri-state area, it's pretty accessible. There's a train that goes right to campus.
Cool.
So, yes, look forward to it. Okay. Now that we have that out of the way, let's go ahead and meet Marissa. There are some conflicting reports on when Marissa was exactly born. Mm-hmm. Some sources say September 14th, 1980, while others say August 8th, 1981. Regardless, her age is not central to today's story, but all the sources do agree that she grew up and was also residing in Jacksonville, Florida at the time of the events we're discussing.
And she would be in her 40s either way.
This takes place in 2008.
Oh, okay. So
yeah.
She would have been in her 30s. Okay.
They're trying to do fast math.
I was, and I am, I can't. So
I'll talk about her age. Don't worry.
All right.
I don't know exactly where she went to school, but at some point she did earn an undergraduate degree and then later a master's degree in business. Mm-hmm. In fact, in 2008, she had a very successful career at a Fortune 500 company where she worked in client services. She was married with twin boys and resided in a beautiful home and was really loving her life. But unfortunately, by 2010, she found herself divorced and raising her twin boys alone. But she found love again not long after, quickly remarrying a man named Rico Gray. Now, the couple got pregnant with their first child not long after the wedding. Some reports say that she was actually pregnant before the wedding, so I'm not sure, but she did have a child very soon after the two were legally wed. Mm-hmm. However, the relationship turned sour almost immediately. In fact, during the last 2 months of her pregnancy, she fled to her mother's house with her twins, and she filed a restraining order against Rico due to domestic violence claims.
Okay.
On August 1st, 2010, only 9 days after giving birth to her daughter, there was an altercation between the two. Now, I believe by this point she was back in the marital home, or at least she was going back and forth, and Rico was not living there or not there at the time. Mm-hmm. From what I understand, she went there when he wasn't around to pack up stuff quietly because she was trying to make a quiet exit. Mm-hmm. According to Marissa, Rico came to the home and he was angry because he saw a set of text messages to her ex-husband. Now, these text messages were innocuous, just talking about the children, but he got very angry and he physically pushed her and shoved her. She says she then locked herself in a bathroom to escape him, but he broke in and threatened her life. She then ran to the garage, retrieved a gun from her car, and returned inside. Now, her twin boys were there, and Rico's children were there as well, because he had children from a prior relationship. Oh. And unfortunately, they witnessed this domestic violence. Oh. Marissa told Rico to leave, and then she fired a single warning shot. Now, no one was physically hurt, and by all accounts, Rico did in fact leave after this shot.
Okay.
From what I understand, it went into the ceiling. So it's not even like she was pointing it at anyone in particular. But I would say what happened next is what shocked so many people. Marissa was arrested and charged with 3 counts of aggravated assault with a deadly weapon, and this was for firing the gun. And even though she filed a motion for immunity under Florida's Stand Your Ground law, her motion was denied.
Why?
Well, the judge found that she had options to retreat, among other factors. So let me pause and tell you a little bit about Stand Your Ground law and what would be some immunity under this law.
Okay.
Now, Stand Your Ground law in Florida was enacted in 2005. And as you know, Meghan, it was one of the broadest self-defense statutes in the U.S. at the time. Now, some key provisions that I want to point out included no duty to retreat. In other words, a person who is not engaged in illegal activity and is in a place where they have the legal right to be, they have no duty to retreat before using the deadly force. That's the hallmark of Stand Your Ground.
Yes, I think so as well.
But then there's also the use of deadly force being justified if the person reasonably believes that such force is necessary to prevent imminent death or great bodily harm to themselves or another. It could also be used to prevent the commission of a forcible felony, like assault or robbery.
I'm just curious then, because then she seems like she was authorized to use.
Okay, well, hang in there for a moment, okay? There are some additional provisions, such as presumption of fear. So if someone unlawfully enters your dwelling, now this could be a residence or a vehicle, then the law presumed that you had a reasonable fear of imminent danger. So this is essentially the castle doctrine, but it was expanded outside of primary residence as well. And then lastly, not relevant to this case, but immunity from civil action. And in some cases, immunity from prosecution. So if a person used force lawfully under Stand Your Ground, they were generally immune from arrests, prosecution, and civil lawsuits. So as you pointed out, why wouldn't Marissa fall under this?
Yeah.
Well, Marissa was claiming self-defense and firing a warning shot. She says she wanted to show her abusive husband that she was serious. She wanted him to leave and she wanted to scare him away.
She had a legal right to be there too. It's her home.
She did, but
he does as well.
Yes, well, that's not even the issue. The issue is that the judge ruled that she did not qualify for immunity under Stand Your Ground because she could have retreated through the garage and she left the confrontation to get a gun and then returned rather than using force immediately.
Her children were in the home.
But he did not have a weapon. And he posed no known threat to the children. So basically, she retreated to get the gun. So 2 things could have happened. If she had used force immediately, or if she had just retreated in general, then it would have fallen under the provisions. But the fact that she retreated to get the gun, didn't use force immediately, and then returned.
Okay.
So unfortunately for Marissa, this denial of immunity would have this case going to trial.
A trial case. And this is just for firing a shot not even aimed at him.
Oh, just you wait, Meghan.
Oh my goodness.
Okay, it's not funny, but sometimes things are so ludicrous that I don't know what other reaction to have.
When you first opened with this case, I assumed that she shot him.
Nope, she did not shoot him. She did not even aim at him. Now, get this. In May of 2012, a jury... Actually, before I tell you what the jury agreed on, can I tell you how long they deliberated for?
Wait, okay, so she went to trial...
It was a quick trial.
Okay.
She was claiming, that she was claiming Stand Your Ground, self-defense. Yeah.
Okay, how long did they deliberate for?
12 minutes.
That's not even a deliberation.
Wait, so that's 1 minute per juror because there's 12 jurors.
That's not a deliberation. That means that the jury, I'm sorry, they did not take their job seriously. That's not a deliberation.
And I failed to mention, because I wanted to wait for this because this is the part that is the most shocking. She was looking at a potential 20-year sentence, and the jurors are taking 12 minutes to deliberate.
No, that's just ridiculous.
Well, it's even more ridiculous when you will learn that they convicted her on all 3 counts of aggravated assault with a deadly weapon.
Surely I'm missing something.
Well, guess what there was in Florida? A mandatory minimum 20-year sentence. So the judge's hands were tied.
Oh, my God.
So she was found guilty of these counts and looking at a mandatory minimum. Now, I want to talk about this mandatory minimum because this was under another really interesting law. Have you ever heard of Florida's 1020 life law?
No.
Okay. And the reason why this law kicked in was because a firearm was discharged during the crime.
Okay.
Now, this law essentially imposed harsh minimum penalties when certain felonies were committed in conjunction with a firearm. As the law says, it could also be a destructive device, such as like an explosive or a bomb, but obviously firearm is going to be more likely. Now, as we know, this takes away judicial discretion. Judges were not allowed to suspend, withhold, or reduce the sentence below the mandatory minimum under most circumstances, regardless of individual circumstances or intent.
Yeah.
So in this case, the judge had no choice. Now, it is important to note that the statute applied whether the use of the weapon was an element of the crime. So even if the felony didn't require the gun as part of its definition, if the offender used or attempted to use a gun, the 10-20 life kicked in.
Oh my gosh. This is unbelievable.
So even if no one is harmed, which is what happened in this case, firing a warning shot could and did trigger a 20-year mandatory minimum.
This is just so disproportionate. Oh my goodness. Please, I mean, there's going to be some like better outcome here. Like she wins on appeal or something. Like this isn't the end of the story.
Well, might I add that if she actually shot Rico, she would only be looking at an additional 5 years. Actually, even if she killed him, she would only be looking at an additional 5 years, 25 to life.
25 to life. Oh my gosh.
So yeah, again, looking at the, how disproportionate that is. And I mean, critics argued about this law in Florida for a while, arguing that it punished defensive acts too harshly. And I think this case highlights exactly what critics were talking about.
Oh my gosh. Yeah, I think so.
On September 26th of 2013, the First District Court of Appeal reversed Marissa's conviction, citing improper jury instructions. So basically, the argument was that the jury instructions unfairly shifted the burden of proof on her self-defense claim.
Got it.
And she was released on bond after being incarcerated for almost 3 years. So she was not out of the woods yet, but there was a new trial ordered.
She was 3 years. Oh, without her children too. Oh my gosh.
Yeah. And remember, one of her baby was, I think I said 9 days old.
I know. That's what I'm thinking. Oh.
Yeah. Almost 3 years puts us at November 27th, 2013 when she was released.
Jeez.
And about a year later, in 2014, state's attorney Angela Corey announced that she would seek a 60-year sentence if Marissa was convicted again. She
60?
She went on to say this would be 20 years for each count to be served consecutively.
Come on. What an abuse of power. That really, you're right. I'm infuriated. I think that is so abusive.
Well, I'm thinking, given what we know about, prosecutions and cases going to trial or being pled out, why do you think, what do you think this was all about? What was the strategy here?
Yeah, they're coercing her into taking a plea because they don't want to go to trial. So take the original 20 years and boom, 20 years is going to look great next to 60 years.
It's absolutely
such an
disgusting.
Abuse of power.
Yep. This is one of the most coercive uses of plea bargaining that I've seen. Now, we've heard of trial penalty before, and this is exactly what we talk about with trial penalty, where she is pretty much being bullied into taking a plea because she could face 60 years for firing a warning shot against her abuser.
This is just so gross.
Now, you won't be surprised to know that this move drew national attention and criticism from domestic violence advocates and others.
Good. I hope they rallied behind her.
And not to mention the stress for Marissa on the fear of facing such a sentence when she has 3 young children. So probably like anyone would do, on November 24th of 2014, Marissa accepted a plea agreement. She pled guilty to 2 counts, and she was sentenced to time served plus 2 years of house arrest.
Oh, they were offering her time served? I thought they were going to try to up the plea, but this is just so they could keep the conviction on the record, basically. So they wouldn't look, this is about saving face at that point.
But again, this just illustrates how ridiculous it is because, if the prosecution is supposed to be standing for justice, you're telling me that the prosecutor is saying this woman deserves to be in prison for 60 years. Oh, but we're going to be okay with her doing time served plus 2 years house arrest. Yeah. So you're admitting that she does not pose a danger to society, because if she did, I would hope that you wouldn't end at a plea like that.
Shame on them. Shame on this prosecutor. Shame on this office. I'm so disgusted by this.
Yeah. So on January 27th, 2015, Marissa was freed from jail and served her 2 years of home confinement. Now, this poor woman, we're going on several years, 5 years of her dealing with this. And this, again, was all in response to her being fearful and her firing a warning shot. And it wasn't, as you could imagine, it wasn't smooth sailing for her. During her house arrest, she suffered extensive bouts of depression and anxiety. I mean, she had been separated from her children for almost 5 years.
I can't imagine.
She was fighting for custody of her baby girl, who was now 5 years old. Can you imagine missing your baby girl's first 5 years of life?
No.
Like we always see, she lost her job when she was arrested, so she had no income. So she is trying to pick up all the pieces here.
What an uphill battle.
Now, when she finished her home confinement, she started coming back to herself. And a few years later, Marissa founded the Marissa Alexander Justice Project.
Ooh.
And she became an advocate and speaker for survivors of domestic violence.
Okay.
And I saw like a TED Talk that she gave. Like, she's a wonderful speaker. She challenges harsh sentencing laws that punish victims of domestic abuse. She's also a certified life coach. She's a mentor. She's really giving back and trying to help other people who are in a similar situation as her.
Wow, good for her.
I considered reaching out to her for this episode. But to be honest, because of time constraints, it just didn't happen. But maybe we could get her to come talk to our patrons.
Do you know what happened to the prosecutor?
Nothing that I'm aware of. Nothing happened to the prosecutor, but there have been a lot of policy changes since Marissa's case. And I would even go as far as to say because of Marissa's case.
I like this. Okay.
So on June 9th, 2017, Florida enacted an amendment to the Stand Your Ground statute.
Mm-hmm.
Under the old law, once a defendant requested a pretrial immunity hearing, they had to prove by a preponderance of the evidence that they were entitled to immunity. In other words, the burden of proof was on the individual to prove or to show that their use of force was justified under the law.
Mm-hmm.
The 2017 amendment changed that burden.
So it shifted the burden to the prosecution.
Well, first, the defendant must raise a claim of self-defense immunity in a pretrial immunity hearing.
Okay.
This means they must present enough evidence that, if accepted, could justify immunity. Now, once that case is made, the burden then shifts to the prosecution, as it should. As it should.
I see.
So
okay.
it's therefore, at that point, the state must try to disprove the immunity claim.
Okay. I see.
Now, I want to go back and talk about some of the wording here because it really matters. Now, the standard the prosecution must meet in the revised law is clear and convincing evidence that the defendant is not entitled to immunity.
Mm-hmm.
So basically, it's like a middle standard of proof.
Mm-hmm.
So remember, before it was preponderance of evidence, which, as we teach, is like just over 50%, right?
Just like a little bit more sure than not. Yeah.
Yes. But it's less demanding than beyond a reasonable doubt, which is what, like 99%?
99%. You have to be like almost, almost positive.
Yes. So now we're somewhere in the middle talking about clear and convincing. And so this evidence must produce a firm belief or conviction that the claim of self-defense is true. Now, what kind of evidence might qualify as clear and convincing? Well, that's a little bit subjective. But in past cases, it would be injuries on the defendant that's consistent with being attacked.
Okay.
Maybe some eyewitness testimony. A neighbor who saw the alleged aggressor maybe go towards the person first.
Okay.
Forensic evidence like a gunshot trajectory or fingerprints showing that the other person held a weapon.
Okay.
Prior threats.
I was going to say that.
Video evidence.
Okay.
So basically, if a judge finds this kind of evidence credible, consistent, then it could rise to the level of clear and convincing proof that the defendant acted in self-defense.
So clear and convincing is the middle ground standard. I don't think I knew that.
When I was doing research, I realized I didn't know it, but I did not know it, if that makes sense. Like once I heard what it was, I kind of, it all clicked in, but I never thought of it as like, what's it called? Not a trajectory.
A continuum?
Continuum, right. Yes. I never thought of it as a continuum until I was doing this episode.
Yeah.
So yeah, like we always say, we learn so much doing this. I love it.
Yeah, totally.
So we see Stand Your Ground got amended, and I would say in the correct way. I think there might be still more work to be done, but at least there's protection for people that are claiming self-defense.
Mm-hmm. Yeah.
Okay, so how about the 1020 life ruling?
Oh, gosh. I just don't like mandatory minimum laws. I really don't.
I know. And this came under criticism not long after Marissa's case, and mostly focusing on these warning shot type of cases where somebody fired a gun, but nobody was injured.
Mm-hmm.
Many people felt, as you and I do, that mandatory minimums are overly harsh in such contexts.
Yeah.
So key changes to this law included removing aggravated assault from the list of felonies that automatically require the more severe mandatory minimum sentence.
Okay.
This reform would give judges more discretion in sentencing in some gun-related felonies that had formerly been rigid under the 1020 life law.
So what did she plead guilty to?
3 counts of aggravated assault.
Okay, so aggravated assault seems extreme, although I just want to play devil's advocate for one moment and point out, especially as someone who trained with firearms, taking a shot, no matter what, even if it was up, can have consequences. There can be a ricochet effect. It could go out an unintended window and hit a child. So it is serious to shoot a weapon. And the warning could have been, I have a weapon. Like, here I have a weapon. So I'm not going to claim that I don't think there should be some maybe sort of repercussion. It seems like it's negligent discharge, though, which has a much lower threshold, lower punishment than this. I just want to say that. And this is probably like for discussion and like, did it get it right? But
yeah, we will discuss that more because I do think it's interesting to think, is this negligence or maybe it's even a little bit more than negligence because she purposely knew what she was doing. Negligence would be like maybe she didn't have the safety on, right?
Right.
Something like that. I just have one more thing I want to mention about the revised 1020 life law.
Oh, right.
Because those who were sentenced under the rigid rulings, they were not granted any sort of reprieve.
I knew you were going to say that.
In other words, it's not retroactive for most cases. And we have seen this issue in so many cases. We see this a lot in cases where there's been a change of law in, how we prosecute drug crimes and people still sitting in prison. But, it's like on the one hand, when you did the behavior, it was illegal. However, it is not practical in most circumstances, and I don't see it meeting any of the goals of punishment. What do you think?
When I lecture on just my intro to criminology course, when I start talking about what a crime is, one of the first things I say is crime is relative from time to time and place to place. It changes in context. What's legal in PA, Pennsylvania, is not legal in Jersey, and things of that nature. And it's really hard to accept, I think, some of these the real punitive laws, especially where someone is not going to be punished, but it's retroactively applied to someone else. And I don't know what the answer is. It's like such an unfair burden in some ways. But then, as you point out, like our laws do change, they do evolve. So what do? We can't necessarily retroactively change everything. I don't know. I got hot talking about that, though. Literally got hot.
It's also a slippery slope too.
Yeah. It is.
And it's not so black or white. So it would be opening up the floodgates. And I think that's probably one of the reasons.
It's such a hard topic. I don't know.
So when we talk about the discussion, I want to kind of frame it. The way I see it is there are 3 main legal or contested issues in this case. Now, the first, I think we've already covered a lot. Marissa claimed she was in danger and acted in self-defense, right? So the first issue that we had already talked about is that Marissa claimed she acted in self-defense. Obviously, the judge had denied the motion. What do you think as far as her self-defense claim?
Yeah, I believe her.
You believe her, okay?
I do believe.
But do you think she should have been granted immunity under Stand Your Ground?
Yeah, I do.
You do, okay?
Yeah, I do.
All right, I kind of agree with you on that. We'll talk again about the point of the discharge of the gun and the danger it could have posed. But yes, as far as her being charged with some form of aggravated assault, unnecessary.
Yeah.
Also, the burden of proof, which I talked about briefly. Remember I said a central point in the appeal was that the jury was instructed in a way that shifted the burden off the prosecution, right?
Right.
So do we think, and I think I know the answer to this, but should the burden of proof be on somebody who is the victim or somebody who's claiming self-defense, that they're claiming that they were the victim?
Well, correct me if I'm wrong, but actually if you use an affirmative defense of self-defense, isn't the burden always on the defendant? By a legal standard in most other cases,
you mean
I
like
think,
insanity, duress?
Yeah, but self-defense as well, I think isn't, I could be wrong about that, but I think the burden is on the defendant.
It is, but should it be?
I don't know.
I know. That's a tough one. That's not like an easy yes or no.
No, it's not. It's not. I have feelings on both sides of it, and I really just don't know. I mean,
I know.
This is tough. This is tough. I mean,
I would love to hear some lawyers' opinions on that.
and we will.
Yeah, I know we
have,
will. Yes.
Yeah, we have lawyers who write in. So yes. Okay.
And then the third, legal area that's really important here is the mandatory minimum sentencing.
Oh, get rid of it. Just ridiculous.
I know.
Just come
But
on.
this also had me thinking, this 1020 life law seems so absurd. I was trying to figure out, why was it enacted in the first place? Because as someone who teaches policy analysis, what do you think the answer to that is?
The mandatory minimums it depends on what it was enacted for, but it's for career offenders, basically, for the most serious offenders that you can imagine, basically, to be more punitive on those types of offenses or offenders, to incapacitate them.
Yep. And sometimes I was also wondering, the reason I went down this rabbit hole is I was wondering if this was a knee-jerk reaction to a crime.
Oh gosh, that's the better. So that's, of course, sorry.
And you always talk, I know that you're the one who taught me about that.
It's like three strikes laws, Meghan's law, right? So it's definitely, it's going to be a reflex.
So there wasn't anything, I thought maybe there would be, but basically the law was enacted in 99 by Jeb Bush. The official
then that's the reason why.
The official slogan was "Use a gun and you're done," and the purpose was to deter gun violence by ensuring harsh mandatory minimums. And we're talking 1999. This is totally in line with what was going on with getting tough on crime. During this time.
This was like the heyday of tough on crime movement, which makes perfect sense.
And the purpose was, just like all of these mandatory minimums, is to shift discretion from judges to prosecutors. And
I
so
hate it.
There wouldn't be able to be any plea deals that would let gun offenders off lightly. I think it was, essentially the purpose was to, deter gun crimes and maybe uniform punishment. I don't know, but.
I mean, they don't necessarily have the worst intentions when they're passed. They just have the worst outcomes. You know what I mean? Like, the legislation might be passed with good intentions and it might even sound good. It sounds good politically, I can tell you that. But it just has such terrible practical outcomes for regular people.
Mm-hmm. And then it had me wondering. This is one of those cases where I started here and I ended up over there. No, but then I was wondering, I'm like, okay, is this something that is rare? What happened to Marissa? Does this happen often? How often are people getting these enormous sentences for similar situations?
I was going to ask you that.
Oh, okay.
Do you know the answer?
Unfortunately, it's not so clear. Because the research is difficult to find. But I can tell you that the research I did find showed that thousands were sentenced under the 1020 life law. And by 2016, over 15,000 people were serving mandatory minimums under that particular statute.
The problem is not knowing for what crimes. It could have been, aggravated assault is very serious and in the way it's usually used. So if we're talking about aggravated assault with a firearm, then I'm not necessarily opposing it depending on the harm and whatnot, but you just don't know in that, who is, who are the Marissas? You don't know.
I did find a case of a man named Ronald Thompson, who is a 65-year-old veteran. He was sentenced to 20 years for firing warning shots near teenagers who refused to leave his home. So again, from what I understand, it was later overturned after he served a couple of years in prison, but it seems very similar. Then there was another man by the name of Orville Woolard who fired a warning shot inside his house to scare his daughter's abusive boyfriend. And this shot didn't hit anyone, but this man got 20 years. And as far as I know, his case was not overturned.
I just don't think 20 years is an appropriate use of that. I'm just thinking about when I said traditional aggravated assault, there's usually a serious harm, a physical harm associated with it. And I really think without that harm, the sentence is disproportionate.
But just to play devil's advocate, what are we saying harm is, right? How do you measure harm? If somebody takes out a firearm and they're intending to harm you, does that not cause you some sort of emotional harm? I do understand emotional and physical harm are different, but
it certainly does.
It's hard to say because these things are not.
If someone brandished a firearm too in front of me, I would be terrified, and I think that would have psychological consequences, no doubt, like PTSD, things of that nature. So I guess I'm just maybe going with this according to the letter of the law as well, and I am parsing out physical harm. a little bit more so. And even if I'm wrong, even if we count that as a harm, I still think the punishment is disproportionate. And brandishing a weapon actually is against the law and can be a crime as well. So I just think there's many different ways to punish this. I don't know, are we there? Are we almost there yet talking about
Yes, actually I was now gonna shift the conversation. You kind of alluded to your thoughts on, what would be the proper punishment. Now, regardless of whether Marissa was a victim of domestic violence, let's just look at the facts of the case. I think there's two separate issues here. How much harm was done by firing a warning shot, regardless of if it was self-defense.
Right.
Now, you brought up a very good point. She was doing it to scare someone, but what if it shot an innocent bystander? There were 4 children in that home, as far as I understand.
Yeah. I don't know, because it's very contradictory for me to also say I think she should have prevailed on self-defense. If she would have prevailed on self-defense, there'd be no punishment, which I recognize, right?
Yes,
because
that's
it's self-defense. So I guess I believed that claim. But let's say I didn't, and I believed that she was inappropriately using a firearm. I believe. So I believe both of those things, which is not fair. Again, contradictory, but. Yeah. I do think that there is potential harm and real risk in firing, in firing even a warning shot. And unless that's really the absolute only resort, that you should not do that. I think brandishing a weapon is enough. So, it's hard for me to say, because on the one hand, I think it was self-defense. And on the other hand, I do think there's some punishment and some responsibility. But it certainly doesn't near 20 years. That is just absurd.
I think in order to answer the question on what the appropriate punishment would be, I always go back to, what's the purpose of punishment? Because if the purpose of punishment is to deter her from doing it again, that's different than if the purpose of punishment is, community safety. Is it restitution? Is it to provide closure for Rico, who was the victim in this crime? Right. So I don't see that mandatory minimum hitting any of the goals of punishment, but not punishing her at all for discharging the firearm, for the warning shot. I think that would be maybe problematic in the view of maybe general deterrence. I don't know, maybe it would send the message to people that warning shots are okay. And as we discussed, warning shots can be quite dangerous.
Yeah, no, I don't know. Wow, this is just a complex case.
It's one of those cases that we leave with more questions than we have answers. Because
sometimes you don't know the right answer too. I really don't know the right answer, but I know it was the wrong answer.
Yes, exactly. I was going to say, for me, eventually the system got it right. I think in the sense that she was granted her freedom, but at what cost of her being bullied into taking a plea and her missing her children's life. She was a domestic violence survivor who, instead of getting help, they put her in the system. So there's just so many issues that, were highlighted here.
Whoever recommended this case, great recommendation. Wow.
Yeah. I'm sorry that we couldn't get to a more concrete place with it, but there's so many interesting questions.
Yeah, it's complicated.
Yeah. If you or anyone you know need help, you can always contact the National Domestic Violence Hotline at 1-800-799-7233. It's 24/7, it's confidential, and it's multilingual. They're also available online at thehotline.org. Another resource, you can contact the National Sexual Assault Hotline, also known as RAINN, RAINN, at 1-800-656-4673 or at rainn.org. Now, they provide crisis support and referrals to local services. I also want to provide a few international resources because we have quite a few international listeners. UN Women Ending Violence Against Women at unwomen.org. They provide global information, initiatives, and resources. Then I came across something called Hot Peach Pages, and it's hotpeachpages.net. And this is a directory of domestic violence hotlines and shelters worldwide.
Oh, wow, that's great.
Yeah, in the past, we've covered cases where we provide resources, and I never came across this one. I think it's great that there's a place to go that has worldwide resources like that.
Yeah.
The last thing before we get to our question today is, if you're interested, check out Marissa's website. You could follow her work and, hear some of her inspiring talks, and that's marissaalexander.com. So that was a heavy one. But before we go today, we have a question from one of our supporters.
Might this be a lighter question?
Not really.
Okay.
But it depends where we go with it. You know, a very similar question had been asked before, but I think it's a good one. So sometimes when similar questions are asked, we bypass them. But I think we should take a minute to discuss it again because it's asked a little bit different.
Okay.
So the question is, how has your parenting been affected through the many years and cases that you've done where children were involved? Now, we did recently talk a little bit about if what we do has made us maybe more...
Are we more fearful? Are
more
we more
fearful, yes. I think we touched on that in a recent episode. So like we talked about last time, it's made me a little bit more relaxed, I think. Although I would assume it would have made me more fearful. But it's helped me right-size some of the dangers. For example, we know the statistics on stranger danger. And
Right.
You know, like I let my daughter, I mean, as you know, she's in middle school. She walks a block or two by herself home from the bus stop. If I wasn't in this field, I might have a bigger fear of, you know, her getting abducted.
Right.
Obviously, you know, knock on wood, it could happen to anyone.
Yes.
But statistically speaking, I feel at peace with the decision to let her walk those few blocks.
Right. Okay. And even though statistically I know what I know, I have a different response to it now that I have a daughter, and she's still young, but I feel like I am going to be, unfortunately, a little bit more fearful or protective because of this. And I also said I have real trouble with child cases now, so it affects my work as well.
I'm just
So that was not a lighter question, but hopefully we answered it.
Not a lighter question, no. As always, thank you so much for your questions. If you have a question, feel free to message us at womenandcrimepodcast.com/contact. And as a reminder, if you are a patron at the Lifer tier, your question is guaranteed to be read on air. Thank you so much for listening today, and we will catch you next time on Women and Crime.
Women in Crime is written and hosted by Meghan Sachs and Amy Shlosberg. Our producer is James Varga. Script editing is by Abagail Belcastro. Audio editing is by Siler Burr and Jose Alfonzo. And music is by Desert Media. If you enjoy the show, please remember to follow and leave a review. You can also support the show through Patreon, where you can get access to additional ad-free content such as exclusive full-length episodes, lectures, a book club, and virtual happy hours with Meghan and Amy. For more information, visit patreon.com/womenandcrime.
Sources for today's episode include Essence, CBS News, Justia Law, Florida General Assembly, Fox News, The Guardian, truthout.org, the Tampa Bay Times, the Miami Herald, the Florida Bar, Politico, and AP News.